Welcome, everyone. My name is Jan Vernick. I'm a professor and senior scholar at the Johns Hopkins Center for Gun Policy and Research, which is part of the Johns Hopkins Bloomberg School of Public Health. And we'll be talking about the Second Amendment and gun policy. No one who has thought about gun policy or worked in the area for any length of time at all can avoid the sort of elephant in the room of gun policy, and that is the Second Amendment. You'll be told that the Second Amendment affects what you do, and that's why we want to talk about it today. The Second Amendment comes from the United States Constitution. It's part of the Bill of Rights. And you probably are all familiar with the part of the Second Amendment that says the right of the people to keep and bear arms shall not be infringed. Turns out, though, that that is not the full language of the Second Amendment. The full language reads, a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. But what does that mean? It's pretty complicated language, funny pronunciation and punctuation notwithstanding. It was written in the 19th century. Who gets to even decide what this means? Do advocacy groups, whether pro-gun or pro-gun violence prevention, get to decide? Does the public get to decide? Does the media, which always has input, get to decide what this language means, at least with regard to gun policy? Well, no. In the United States, it's the courts, ultimately, that are the final arbiter of what any part of the Constitution means. And in particular, when the Supreme Court speaks, this is a picture of the Supreme Court in Washington, D.C., when the Supreme Court speaks about the meaning of the Constitution, then all lower courts have to listen and follow along. So what has the Supreme Court and other courts said about the Second Amendment? Well, actually, until recently, no federal court had ever struck down any gun law as a violation of the Second Amendment. In fact, in 1939, the Supreme Court, in a case called United States against Miller, upheld a law regulating sawed-off shotguns and machine guns. It said that that federal law was not a violation of the Second Amendment to the Constitution. And lower federal courts, since 1939, have followed along. Here's an example. In a case called Caliche against Village of Morton Grove, a federal court of appeals in 1982 actually upheld a local law in Illinois that basically banned the private ownership of handguns. So even a law that essentially said that private people couldn't own handguns until recently was not seen as a violation of the Second Amendment to the Constitution. I can't resist telling you a little side story about what followed this case called Caliche against Village of Morton Grove. After the case was decided in 1982, the good people of Kennesaw, Georgia, were frankly incensed that the town of Morton Grove in Illinois would pass a law that basically banned all handguns. So they enacted their own law in Kennesaw, Georgia. And the Kennesaw, Georgia law did not say that private people couldn't own handguns in Kennesaw. In fact, what it said was everyone in Kennesaw, Georgia must own a firearm, including the ammunition that was needed for it. So just a little side story for you. That law remains on the books. If you've read it, as I have carefully, it actually says that everyone in Kennesaw must own a firearm unless they don't want to for some reason. There are lots of exceptions for people who just conscientiously object to owning a firearm. Anyway, that's an aside. So back to the Second Amendment. All of this changed in 2008. Prior to 2008, no federal appellate court had ever struck down a gun law as a violation of the Second Amendment. But in 2008, the Supreme Court agreed to hear what is now the landmark case of District of Columbia against Heller. And in our next segment, Professor Adam Winkler of UCLA and I will discuss both the present interpretation of District of Columbia against Heller and what we might see for the future. I'll give you a little preview. The preview is that even though the Supreme Court in District of Columbia against Heller said that the Second Amendment actually does protect an individual's right to own at least a handgun in their home, and as a result struck down Washington, D.C.'s virtual ban on handguns, lower federal courts and other state courts have actually upheld almost every other kind of gun law other than bans on handguns.